welcome. Now, I recognize we have lots of people with us today. We do have 5 defendants. So I'm going to call everyone individually, and if you'll just wait until I call your particular party, then announce present. Do I have someone here on behalf of our plaintiff, Longee Lobo Prabhu? Good afternoon. And sir, you're on mute, so you will need to unmute when we get started with proceedings, okay? You can press *6, or if you're in the Zoom app, on the lower left.
Yeah. Thank you.
Thank you. All right. Who do I have on behalf of Amazon Logistics?
I am here on behalf of both Amazon entities.
So you're here for logistics and services?
Yes, Your Honor.
Okay. Good afternoon, Mr. Fisher. Who do I have on behalf of Progressive? Mr. Kittrell, is that you?
Yes.
Do I have anyone on behalf of Allstate?
John Stillwell.
Good afternoon, Mr. Stillwell.
Hello.
Do we have anyone on behalf of Kubenga Jabulani?
I sent him the notice yesterday via email to see if he got it. I thought he would be here, but I don't represent him.
All right.
Judge, I think that's the person that was insured by Progressive that was served by the plaintiff. And Mr. Basham was saying that he has been in communication with him. Everybody's trying to get Progressive to answer for him. So,
All right. We're going to go through it, y'all. There's a lot of pending issues.
Yes.
So just on my notes, today, things that we have before us are an original motion for discovery from our plaintiff. Defendant Progressive has a pending motion to dismiss, so that's with Mr. Kittrell. We have from Logistics, Mr. Basham's client, special exceptions that was filed just a matter of days ago. Ultimately, let me just kind of summarize. I read the petition. So our plaintiff is suing, sir. It sounds like were in a vehicle and your vehicle was struck by an Amazon delivery truck.
Amazon Flex delivery driver in his personal car, but he was in an Amazon uniform.
All right, but it is from a car collision.
Yes.
All right, and you're seeking your actual damages. You've also included things for emotional damage and an apology. I will just highlight for you, Mr. Lobo Prabhu, that emotional damage is not recoverable in an action like that. So that portion of your claim would be struck by law. It cannot be recovered.
Sure.
And also, even if someone is at fault, there's no law in the world that's going to make them apologize to you. Morally, you might have earned it, but legally it can't be included.
All right, sure.
Other parts of your petition are fine, right? At least in terms of what he's seeking. That's just information, y'all. Okay.
Yeah.
Before we do the motion for discovery, because that's going to really depend on who our defendants are, let's take up first Progressive's motion to dismiss. So, Mr. Kittrell, good afternoon.
Good afternoon.
All right. Tell me, what is Progressive's position? Why should you not be a party to this case?
So we shouldn't be a part of this case because we're a third-party insurance company for the person in this lawsuit, or no, I'm sorry, for one of the defendants in this lawsuit. But this is not a direct action state. You cannot sue another person's insurance company because it's a contractual matter between that person and Progressive.
All right, Mr. Kittrell, who is Progressive the insurer for?
Is defendant Maposa, the person involved in the collision.
I don't show that person as a party. I have Amazon, Progressive, Amazon, Allstate, and Jabulani. Are you saying that your client should have been sued, but instead they sued Progressive?
That's what I have been told. I am confused on whether he was served and sued as well, because we never got an amended petition stating that they had been added to the lawsuit. Honestly, so I don't know if they were served and sued. I saw that there was a motion for default against him, but I did not see if he was served and sued.
It's not in there. The original petition was against Amazon Services was defendant 1 and defendant 2 was Progressive County. And then it came in, they got Logistics and Allstate, but I don't have any. What is the name of the insured that you have, Mr. Kittrell?
Yeah, it is. Go ahead. Someone was. Oh, I thought someone said something. It is.
I was gonna say, Judge Holmes. So sorry to interrupt. There is the Mr. Maposa. It is the very last one. I'm not too sure since it's such a long name if it cuts off, but they're the last defendant listed. It was on the amended petition. And
yeah, Mary, Mr. Kittrell, what is the name of your insured?
No problem. It is Jabulani Kupenga
And he's a
Maposa.
defendant. You told me Maposa. That's a long name. She's right. Got it. Then the defendant who's not here is your client, but you don't represent him. You're just his insurance agent. Or Progressive was his insurance company.
Progressive is his insurance company, but I just represent Progressive. I don't represent him at all.
I got it. But he
Gotcha.
has a policy with you. So if he's sued, he could hire you and you end up coming back to represent him, right?
If that's the case, then that's their prerogative. But I represent Progressive individual or as a company.
Mr. Kirschel, I understand that. I'm just pointing out the funniness of how that works. Okay,
Yes.
got it. Mr. Lobo Prabhu, good afternoon.
Good afternoon.
He's absolutely right. Mr. Kirschel is correct. The person you allege that was driving that actually caused the collision, is that Mr. Jabulani?
Yes, Mr.
Okay.
Maposa. Yeah.
Then you absolutely can sue Mr. Jabulani if he caused the collision, but you don't get to sue whoever his insurance company was. He has a contractual right with them. I'll give you an example. Let's say you are struck by a defendant and it's not a dispute. The defendant caused you the damage.
Yeah.
If the defendant has an insurance policy, after you win, you can send that your claim to the insurance company and they may pay it out. But they're not a defendant to the lawsuit because they literally did nothing wrong. They just happen to insure that guy, right?
Yeah, agreed. One quick clarification. So this serves as notice and an opportunity to appear to the insurance company, correct?
No, the insurance company doesn't have to be here at all. That's why I'm going to sustain Mr. Kittrell's motion and dismiss Progressive.
Can I,
Mr. Jabulani needs to be here and he was properly served a notice. So him not showing up works against him.
Yeah,
But
Can I-
he's not Progressive. Those are two completely different things.
I understand. Thank you.
All right.
Your Honor, could I'm John Stillwell. I'm the underinsured motorist carrier attorney. Can I interject something?
Okay.
I've been in the shoes of the Progressive lawyer many times, and the law is that there's no direct action against the insurance company unless there's a default judgment entered against its insured. Then the plaintiff could come to Progressive and say, okay, I'm suing you because you didn't answer for your insured and your insured didn't know what to do. And a default judgment has been entered against your insured. So now I'm seeking Progressive. And then as a matter of law, the plaintiff can pursue Progressive for that same judgment. So I say all that to say, as a practical matter, I've done this for 30 years. This is all that I do. Basically, 99% of what I do is car wreck. As a practical matter, at the end of the day, Progressive is going to owe either a defense or they're going to need to have to pay for the default judgment. And so I'm not sure why we would dismiss. I think Progressive's trying to catch the plaintiff on a technicality. It's not, the limitations have not expired yet. And the plaintiff has properly asked the court for a default judgment because Progressive won't answer. Because it's my understanding, the plaintiff could tell you.
Mr. Stillwell, plaintiff has not motioned for any type of default judgment.
Sure
He's still
did.
seeking discovery.
I
Sure
did.
did.
I
We're
have,
not there yet.
But he
Okay.
filed one a week or two ago.
We're not here for that today.
okay.
Well, but it's it's my understanding it was he filed it and it was set. And if there's been service and we're in court, he's allowed to ask for default judgment at any time. And I think I don't understand.
Stillwell, are you representing the plaintiff or your client?
I represent the underinsured motorist carrier that only is liable if Progressive is let off the hook. If Progressive is let off the hook, then my client is liable. So yes, I have a financial and pecuniary interest. Plus, as an officer of the court, I have a duty of candor to the tribunal, and I have a duty to make sure that everybody is honest and straightforward with the court. And I think that Progressive's motion is not well taken. And as a practical matter, and I think Daniel and I have talked about this, I think Daniel agrees, the person who is driving ought to be in the case. He's been served. These people don't know. And
It's not a disagreement, Mr. Stillwell. He has been served and he's not here.
well, and so it's incumbent upon the court as a matter of law to grant the default judgment requested by the plaintiff, and it was filed, what, more than 10 days ago, and there hasn't been service. The court wasn't, and no offense, but the court has a lot of defendants here, and like your clerk chimed in and says, yes, that person is a defendant, and they were added. I don't remember the exact date the motion was filed, but the plaintiff could maybe address that.
Judge Holmes, can I please? That would be a contractual matter between Progressive and its insured. It would not be a matter of this default judgment. This default judgment would have to come after the fact. It has not been ruled on yet. If that has not been ruled on yet, then we don't have that. That is a contractual matter between the Progressive and insured and themselves.
That's not exactly true. Progressive has told the plaintiff that they didn't. He can tell you what Progressive has told him, and the motion for default judgment is ripe because it's been filed, and it was been filed more than a week ago. I think it was 2 weeks ago. It was filed. When was it filed, Ranjit?
More than 2 weeks ago.
And there's been service, and just because Progressive is trying to dodge its liability, as a matter of law, as a matter of law, once he gets a default judgment against them, then Progressive has to step in and defend itself. And, you know, it seems like we've got a pro se plaintiff who doesn't know the law. And I feel like somebody's dodging responsibility when they know there's a case out there. He's been in communication with Progressive. Progressive knows the person's been served.
And I would say I've been able to speak with Mr. Maposa. If anything, I would request the court at least give a little bit more time. I can try and talk with him again so he can provide actual notice to Progressive, which I thought he was going to do, and then they will have that requirement to, come and, answer, provide a defense. I think that would be a fair resolution because, like you said, Allstate and Amazon both, say that Progressive's going to be the one that's liable here. So
thank you, Daniel. And that's kind of, like I said, I represent Progressive here today. As of today, there is no direct cause of action against Progressive. So that is where I have, if they want to request a defense, that is his doing. That is his contractual matter between Progressive and himself.
Well, Progressive should, when they know he's been served and they're communicating with him, they should say, all you got to do is say you want a defense. It's like my wife laughs about the magic words that these insurance companies are requiring. The practical matter is, especially since we're in justice court, we ought to be trying to get to justice, and that is not dragging this case. The bottom line is the plaintiff has tried to serve and has served, I guess, this Maposa, and even Daniel has spoken to him and verified that. Is that right, Daniel?
He said that he believes that he received a service via certified mail. That's as much of a confirmation as I got. And
the case law does say that once there's a default judgment, I'm not sure what the impediment to grant that would be. Progressive's on the hook. And after all, they have insurance. And I mean, they've even got a lawyer, but their lawyers only focus on they didn't use the magic words, we want a defense. Maybe they didn't use, I don't know what communication has been between this Progressive insured and Progressive, but the practical matter is my client Allstate shouldn't have to pay because somebody is playing games with the system.
How's Allstate involved in this?
We are the underinsured motorist carrier for the plaintiff. So in the event that the court would let Progressive off the hook, then potentially we would be on the hook because Progressive is let off the hook. The person has asked for, this person has communicated with.
Now, Mr. Stowell, that's not actually correct, right? So in the world we're all in here, right? Sounds like plaintiff hasn't done anything wrong. If I'm listening to the three of y'all, no one actually knows what happened. So let's assume plaintiff's case is true. The driver, Jabulani, caused the collision, right? If today plaintiff wins against Jabulani, as you pointed out, plaintiff can then pursue the claim through Mr. Kittrell's firm, Progressive. And if Progressive has to pay it out, I'll put it this way. Let's say Mr. Plaintiff doesn't want to bother. He says, listen, I already have a policy. I want my money from Allstate. Allstate, you pay it out because he has that right if he's got comprehensive coverage. You then bring a claim against Mr. Kittrell's client, Jabulani, for the same thing.
Actually,
And then you can present that default, which you would automatically win, to Mr. Kittrell's firm, and at that point, Progressive would pay it out, right?
actually, as a matter of law, we get an offset for the amount of coverage that this person had with Progressive. So if the plaintiff doesn't know how to do it right, and if the court lets Progressive off the hook just because.
But plaintiff has you as their Progressive insurer. They can call you, your Allstate, and that's you insure the plaintiff.
But we don't have to prosecute the case for them. I have, as a courtesy, as an officer of the court, I am trying to advise the court and the plaintiff that they have the right to get a default judgment, which they can do and have done or have requested for, and I'm not sure what the impediment is for that. And the plaintiff has told me he wants to pursue the Progressive insured who caused the accident in his mind.
The insured.
And you know what? And he has asked Progressive, and they say something about, I'm not sure the words. Rajit, can you tell her the words that they've used to you? Something about they didn't.
He wasn't in status to that, something to that effect.
Was he
They
insured
tried
at
to
the time of
correct
the
his,
collision?
they tried to correct his policy. So there is some issue with unknown with his policy where Progressive is refusing to honor its obligation to him.
Judge, the deal was he was working for Amazon, from what Mr. Ranjit says at the time, and the plaintiff can verify or not that. And then as a result, he sought out requests for relief from Amazon. And then Amazon says, wait a minute, he wasn't our driver at the time. And then I think from talking to the plaintiff, it sounds like what happened was Progressive saying, no, it's not covered because he was working for Amazon, and Amazon say, no, it wasn't covered because he wasn't working for us at the time. Is that right, sir?
I have no idea because none of the insurers have given a reason. Amazon has said that he was out of compliance. What does out of compliance mean? You expect Amazon to hold its drivers to compliance?
We said he was out of block. He was no longer delivering for us. He wasn't
No,
scheduled.
no,
So he's not
the
the course
letter
of
that
scope, not
excuse
compliance.
me, Mr. Mash, sorry for speaking over you. The letter I received said that he was out of compliance, and I have that letter with me. So
It sounds like they were saying he wasn't on the clock at the time, or not.
yeah, so whether it was what out of compliance means, whether he was not on the clock, whether he did not have the correct insurance, secondary and third-party insurance, or whatever other reason, I do not know.
And my guess is Progressive is saying, wait a minute, we cover him, but he was on the job and on the clock for Amazon, so we're not covering him. And so you've got two people that are going like this.
Yeah.
I like Mr. Daniels' suggestion, and that is to give Daniel and or Ranjit an opportunity to try to convince. I would suggest write it out for him. Say, Progressive, I was served and I request a defense, and click your heels together 3 times, and then they have to provide a defense.
Or if you're saying there is no defense, then we can move on to the default motion, a motion for default judgment.
Are you withdrawing your motion for discovery?
my motion for discovery, if I get a default judgments against the things, then the motion for discovery will stand withdrawn because the case will will go towards a conclusion.
No, it wouldn't, sir. You only sought a default judgment against the individual. You have 4 other defendants. So the case would remain. You would have to either non-suit or do something with them. And I haven't yet heard from Amazon Logistics. Y'all have not said anything. Why are y'all still here at all?
Why is
Y'all made a
Amazon?
motion to dismiss. Yeah, so what's going on? Y'all made a special exception. Give me your version of this, because I've heard a lot from Mr. Stillwell. I've heard a little bit from Mr. Kittrell.
Okay,
What about
yes.
Logistics
So-
Services? What are y'all doing in this case?
So Mr. Maposa had been driving as a delivery partner in the Amazon Flex program. That's the program where you drive your personal vehicle, deliver Amazon packages. He was on a delivery block until about 15 minutes prior to this accident. He had like finished delivering all of his packages. He was no longer using the app. He was not performing a service for Amazon within 15 minutes before the accident. At least that's what I have seen in the documents that we have and in my speaking to Mr. Maposa. 15 minutes after he finished, he was in the accident with Plaintiff, and he, I believe, was in his wife's car, is what he said, and he said he might have given her insurance instead of his insurance, and that was some sort of confusion that happened at first. But then now it is my understanding that, like Mr. Stillwell said, Progressive was denying coverage because he was using his vehicle while performing services for Amazon. Amazon saying, hey, he's out of course and scope, coming and going rule. We're not vicariously liable. And so we think that Progressive is who's involved. Our special exception, was pointed towards his plaintiff's lack of specificity in his petition, where has not identified how or given any facts that can implicate that Mr. Maposa was in the course and scope of his employment to where we can be held vicariously liable. He can't plead those facts because he wasn't. But I mean, the main reason that we are here is, as we pointed out in our response to the motion for discovery, is, if you're going to allow discovery, to limit it to just those documents that show that Mr. Maposa was not in the course and scope of his employment, so Amazon is not vicariously liable. And if we're going to have to produce those, we would want a protective order entered so those documents can remain confidential, because Amazon is a technology company and take the proprietary data very, very serious and keeping that confidential. That's the main reasons we're here.
Mr. Basham, where this accident was a serious accident, and my son and I were almost killed. The keeping of everything confidential is not in the public's best interest.
I don't think that we're here to argue the merits of the seriousness of your accident. And I'm not sure that there is really any kind of impact in the analysis of whether a protective order should be entered in the event that you allow discovery. I don't think that is a factor that would need to be considered by the judge.
Okay.
And Ranjit, that's something I would actually agree with Amazon. I mean, this is a small claims court where there's generally not discovery unless the court allows it. And Amazon's a company that has the right to certain things. But if there's discovery, it should be limited to was he on the course and scope of his employment or this app or whatever? And that should be it, I would think, wouldn't it?
Yeah, if there was no negligence on Amazon's part in terms of how the car was equipped and things like that way, beyond that.
Your focus ought to just be on the person that had the accident with you. And you
Yeah.
can either give them, get into the case, and they can either tell you or the court whether, and Progressive and Amazon, were they working for Amazon? They can answer that. Were they not working? Therefore, it would be covered by Progressive. That's all you need to know.
Yeah, yeah, that's all we really need. So I think
Anything else?
if we accept Amazon's answer that he was not working for them, then it becomes entirely on Progressive, and Progressive doesn't want to be part of this case.
Well, and maybe Amazon has something that they can show you in writing that says, look, he was not on the course and scope of his employment. That app or whatever he's talking about was not on.
Right. And we do have documents showing that. It's just we would want that confidentiality protective order in place prior to producing that to make sure that our proprietary software data information is protected. And, I think, if we can get that in place, and I can get that out to the parties, and you see we're not in the course and scope, you can, I think it'll all kind of land back on Progressive, and that's why I would kind of go back again to my suggestion of let's give Mr. Maposa a little more time to get actual
You shouldn't
notice to Progressive.
He's had his time. He's had a year and a half. Progressive has had a year and a half.
Well, you need to write it on his forehead. Hear me when I say, you need to write it on his forehead, on his hand, whatever. All he needs to do is say, Progressive, I've been served. I want a defense. That's all he needs. I think it's inane that is something that anyone requires. And frankly, the case law, that the Crocker case that set that place in motion shouldn't really apply, because it involved an additional insured on a commercial policy, but that's what some a lot of insurance companies rely on. They need to just ask for a defense. That's all they need to do. And whether or not, you don't need to post on YouTube this thing that Daniel he just wants a simple confidentiality. I don't even care if I ever see the document. You should just sign whatever it is and say, yeah, you'll keep it confidential between you, the court, and Daniel.
Yeah.
And at the end of the case, it's shredded. There's no reason for you to want that information.
Sounds like the court should order parties to mediation. That would probably all work this out like that.
That would be fine with me. That would be fine with
Excuse
me.
me. Can Judge Holmes?
Yes, Mr. Kittrell.
Sorry, I don't mean to interrupt. I'm just trying to, like we said before, there's not a direct action state, so he doesn't have the case with Progressive. If he wants to go out and sue Mr. Maposa, that's his prerogative. If Mr. Maposa requests a defense, that's fine. But as Progressive, as a direct action in this lawsuit, we are not supposed to be a party. So if
do you know if Mr.
wants to be a
Maposa's
party,
requested a defense from y'all yet? He said that he was going to inform y'all.
And the second the default judgment is entered, if the judge says, okay, I agree, default entered, then Progressive's on the hook.
so long as there is coverage. But I'm not here for coverage. That's not my issue. I'm here for Progressive as a direct action in this case, and that's not my argument. My argument is, Texas is not a direct action state, so you cannot just go sue somebody else's insurance.
The second there's a default judgment, like the court said, I think mediation would be appropriate. But the second a default judgment's entered, then Progressive could say, you know what? There is no coverage. If I was Progressive and their counsel, and I've been doing this for 30 years, I would say, you know what, folks? There's no coverage anyway. He hasn't asked for a defense, but there's no coverage, and this is why. If you did that, then there would be nothing to talk about, or there'd be less to talk about. But nobody's doing that. You're trying to get off, and I understand you've got some young adjuster somewhere saying, file this no direct action motion. And I filed them too, but you got to put lawyering aside and put equity, think about equity.
I would say you both need to follow the contract with your client, right? If I just jumped in to be an attorney for someone because they hired me to do something else, I might get in trouble. And if Mr. Kittrell, on behalf of Progressive, just decided to take over the case, he might have a problem with Mr. Kubenga Jabulani Moposa, right? So I hear an issue in that one. But gentlemen, you've all raised a lot of issues. We haven't actually resolved anything that was pending before the court.
With the
Plaintiff
court,
had filed a motion for discovery. Y'all just jump right past that. Plaintiff filed a motion for default against only one of the 5 defendants. One of the defendants has a pending motion to dismiss. The other one has a motion with they made special exceptions, right? It sounds like Mr. Stillwell, you and Mr. Besham have had a lot of conversations with each other. You're eager to make sure that Mr. Kubenga is found responsible, in which case Progressive will have to pay out on the policy.
we've had
I am
one.
not aware of any rule, unless it is in the contract with Progressive, that they should just automatically rise up and defend upon being aware that their client might have a cause of action. I don't think that's what's required of them. And they're not a direct cause. You are correct that if they win the default, then it may go over, but we're not at that stage.
But the motion, default,
Mr. Stillwell, we are not at that stage. There is a pending motion, but there are multiple pending motions. I haven't ruled on anything. Today, we were here so we could make some rulings. It definitely sounds like you all know what you're saying. No one here is defending the one defendant who didn't come. Is there any evidence that y'all are aware of that's going to disprove that he caused the collision with the plaintiff?
we don't know because we haven't done any discovery. And he's not in the case.
I've spoken to him. I would say that there's no evidence I'm aware of that's going to disprove his liability. I'll admit that.
But we don't know if he was negligent. And we just don't have hardly any information.
We don't need any for a default.
Yeah, and you can only take a default against a party that hasn't answered.
Yeah.
And so, I mean,
You were eager for me to grant the default.
no, I'm just eager. I like Daniel's suggestion and or the courts. If we all go to mediation, probably the right thing will happen.
100%. I see everyone's got a valid point to be arguing here. I don't think you're arguing. I think you're all doing a very nice job representing your individual clients within the capacity you've got, right? I see that. So 2 thumbs up from our counsels today. And for our plaintiff, you're doing a lovely job. And truly, you're getting some really good lawyering here, which are very particular issues of fact and of the law. So I like that. Certainly the person we all want to see is not here, right? Not here. He has been served. Let me give you all some information because Mr. Lobo Prabhu, your motion for default is still pending before us, right? That is true. That is still before him. When I look at your motion, here's some things that I highlight. So the things that you sought would be actual damages. All total is $88.68.56. That's the $84.64 for your body work, $299 and change for tires, $101 and change for another rim, and then I would include the $200 estimate, right? So that together is $88.68.56. The $2,000 of diminished value. Do you have proof for how you came to that number?
That was from my Carfax estimate, and it's the difference between an undamaged car and a damaged car. That is how that's the only way to come up with that. I think the insurers have a better way of calculating it. I will default to any way that is equitable that the court agrees with of
All
calculating.
right. How about you said $500 for loss of use? Did you incur any rental car expenses?
No, this was any time that this was the time that the car was actually being repaired. It couldn't be used.
I understand that, but I got it. You have to have an actual damage. I can't just give you money for not being able to drive. You may have been on vacation
Okay,
that week.
so then
did you have to rent a car or pay for Uber
No.
or spend money to travel? Okay,
No,
I can't give you that one.
you can strike that.
Okay, all right. Cost of court always come in for things.
And Judge, without anybody paying this was a very difficult case to expensive repair to undertake.
All right. Listen, we did not set the motion for default here. It was filed after we'd already set this hearing, right? So it would be improper for me to hear it today. But it is pending before the court, and certainly we'll take a look at it. Defendant has not filed an answer. I don't see an original answer from that defendant. We see one, let me just confirm. I see one from, on behalf of Amazon Services. And that was also for Amazon Logistics. So we got Amazon covered. Progressive, Mr. Stillwell, your firm sent in an answer. We got an original answer with a jury demand from Allstate as well. And then we got, I know, Mr. Kittrell, we got a very specific one from Progressive, but we never got anything at all on behalf of the individual defendant. All right. I have a bit of an informal answer that I think may get us all, will maybe get all of y'all where you're aiming to go. Because it seems, right? And certainly if we never hear from the individual defendant, the default will be granted on behalf of the plaintiff. And so that's kind of, as I'm reviewing your plaintiff's petition for the default, that's where I'm at with it. So what I think we can do is this. Why don't we, court will take under advisement all the motions from the parties. And Mr. Lobo Prabhu, I understand what you're saying is that if the default is rendered in your favor against the individual defendant, you would no longer wish to pursue the motion for discovery?
Yes.
Okay.
And
All right, you don't have to do that. You don't have to do that. It tells me some information. Let's provide 60 days. Three of you for our defendants, Mr. Basham, Mr. Kittrell, Mr. Stillwell, you're all counselors and all officers of the court. Would you like me to just give you 60 days for conference, or would you like me to order a mediation?
I'd love a mediation if we could do it maybe remotely by Zoom, but
We usually refer for justice court here in Travis County. We refer to the DRC. That's just our standard because we get so many pro se people. If y'all want to do any version of mediation amongst you with something else, but certainly I don't have any issue with doing it via Zoom.
I think just 60 days for conference might be more appropriate, as I think within that 60 days, I can probably get Mr. Maposa to follow through with getting the proper notice to Progressive.
No, I'm listening again to that. So the person most likely to have an impact on getting that defendant to respond is his independent contractor or employer and not his insurance agent.
well,
I mean, no, that makes the most sense, right? Like, who's more likely to hear from him? The company that cuts him a check for the work he's doing, as opposed to the company he sends a check to.
that's a great point.
He doesn't work. He doesn't work for him anymore.
Okay.
Well,
That seems actually, I think that seems, why don't we do this? Let me give y'all 60 days, and I won't make it a formal mediation. I'm gonna say 60 days to confer. Mr. Fashion, do your absolute best to get a hold of the defendant. In that interim, I'm going to review, Mr. Lobo Prabhu, your motion for default, and certainly on its face, if defendant does not answer, it's going to be granted, and then it would come to you, and then you have your options at that stage of if you wish to non-suit, and that may resolve any outstanding negotiations or things that need to go on. If you wish to continue pursuing, you absolutely have the right to do that with the remaining defendants. All the remaining defendants have the right. Your motions have not been ruled on. So Mr. Kittrell, have not ruled on your motion. It's still pending. I hear, though, the totality of the situation.
yeah.
And I think everyone's kind of in the same line of where you're aiming to get and where it looks likely to be going, but we don't know. All right, 60 days, parties can confer. If you don't come to an agreement or we don't have the case resolved, you can ask for formal apparent mediation. Then we would absolutely say you got to go and do it that way. You can always come back. You can raise any pending motions before the court and say, Judge, now we really do want to have discovery, or I want to get my motion to dismiss ruled on. I will certainly rule on the motion for default unless or until I hear from that remaining individual defendant. All right.
60 days will cure it.
I got a feeling you're going to get there.
Daniel is going to do a good job, and Ranjit, you've got till July 17th to do what you need to do.
By the way, Mr. Stillwell, that was my boss you've spoken to. We've never spoken before.
Okay, I spoke to somebody one time.
Yeah, that was John Bridger.
Okay, well, he's nice.
Yeah.
He's a good guy.
Okay.
All right. Mr. Lobo Prabhu, are there any questions that I can answer? So today, the court has not ruled on anything. All of the motions are pending. I'm asking y'all to take 60 days to see if Mr. Basham can get a hold of, understandably, not his client, but he may be the most likely. Mr. Kittrell, you here, certainly, right? in that interim, I am going to review and rule on your motion for default. Certainly it would go your way if we don't ever hear from that individual. All
Okay.
right.
And,
Alright.
one quick question. The reason I'm doing this, I'm progressing with this case is that one of our own Travis County Sheriff's deputies died in exactly the same manner at exactly the same spot back in 2021.
Oh, wow.
So it is a serious thing to be pushed across 3 lanes, exactly the same, and this is not a frivolous case.
Not at all.
Yeah. So
No, nothing about it.
and it's a really
There's never
sad.
been that allegation, sir.
It's really sad that a year and a half has gone by and no one is willing to take responsibility for it.
Well, and if you want to call me like I've asked you before, maybe you and I could settle out Allstate and you, we could settle it out.
Yeah.
The fortunate weekend. Feel free to call me anytime. You've got my cell phone.
Will do. Thank you.
Counselors, we'll go in order. Mr. Basham, anything for logistics or services?
No, if we're still waiting on the discovery and all that, then no.
Okay. Mr. Kitchell, anything further?
Nothing further.
All right, Mr. Stillwell?
No, ma'am. Thank you for
All
your.
right, thank you. Thank
Yeah,
you
thank
all.
you.
60 days, see if y'all get where you want to go. I'm going to rule on the default judgment no matter what in that interim. And that, then certainly Mr. Basham, Mr. Kitchell, Mr. Stillwell, that judgment may also lead to additional things for y'all. All right?
Okay.
All right, thank you then.
Thank
We'll
you.
send y'all a new court date.